This is an appeal in the matter of Allen and the Secretary of State for the Work.
My Lords,
Yes.
I appear on behalf of the appellant in this matter. My learned friend, Mr. Heppenstall, leads Mr. Castle on behalf of the Secretary of State.
Thank you.
We have noted Mr. Castle appeared below in front of the Upper Tribunal. My Lords, before I proceed to my substantive submissions, can I just confirm you have what I think you should have?
Let's hope so.
It's a core bundle totaling 171 pages.
Yes, looks like it.
And the intention and understanding is that the PDF pages will match the paginations. And the
I think we're all. No, do you?
I'm using.
Well, I think we're all
Yes.
paper. Yeah.
And the authorities bundle totaling 479 pages.
Right. Thank you.
In broad terms, my submissions will fall within three parts. Firstly, I have some introductory remarks setting out the appellant's stall on the facts of this case and what we asked for. Secondly, a somewhat dry but necessary trawl through the statutory provisions.
Yes.
And thirdly, I will address head-on some of the authorities specifically in relation to criminality, not disentitling an individual from statutory right, namely the case of Best, and the authorities cited by my learned friends in relation to tax and trade cases, Aiken and the like. Firstly, my Lords, the background to this case. It is right that we are here asking you to uphold a first-tier tribunal decision in the context of an appellant that acceptably, over the relevant period, so between the 1st of October of 2014 and the 5th of April of 2016, was involved in a criminal conspiracy involving the selling of bikes. It is accepted that in the course of that offending, the appellant, throughout the period, had money to the effect of circa £30,000 running through his account.
So he was involved in criminal. He was selling bikes.
Yes.
We'll have to look later what that entails, and receiving money.
Yes. However, to the extent that this court may be concerned about overturning a decision that removed that entitlement, we say this. First, the appellant was subject to condign punishment. He, after trial, was sentenced to 4 years imprisonment and served 2, being released in 2018. And secondly, to the extent the state could have, there was an option for a benefit for a prosecution. And you may have seen, as accepted by the First-tier Tribunal, that was discontinued following the conviction. So the point is this. Our case is, on a clear read of the statutory provisions, notwithstanding that underlying criminality, in the context and purpose of employment and support allowance, that criminality does not and must not disentitle him from the allowance. And that is because, by dint of ground 1, Regulation 19, which I will of course come back to, the question and the findings of the First-tier Tribunal were abundantly clear. The appellant was incapable of work, and that is an analysis on the facts in light of his long-term depression and in light of his drink and drug addictions requiring treatment. Those are the circumstances that we say are inherently linked to the criminality, which in the context of employment and support allowance will be shown to be consistent with Parliament saying we wish to support that individual back into the legal workplace. We do not wish to sustain him in the illegal workplace. So that is perhaps a question of mixed fact and law under ground 1 and limited capability to work assessment. But it's what can he do, what can't he do, and in what context do those things happen or not happen. Ground 2 is simply that work for the purposes of the relevant provisions must be construed, literally and or purposefully, being inclusive only of legal work. Our position is, had Parliament intended to include illegal work, it would have to be expressed. Patently, it is not. And even if we are wrong about that, a clear-eyed view of the statutory purpose behind it sees that it cannot be inferred or implied that Parliament intended legal work to be incorporated. Ground 3 is a similar argument in relation to income. We simply say work is legal work, income and earnings is income and earnings legally acquired for reasons that will become apparent. Now, ground 4 does to an extent overlap across all other grounds. It simply says that it is relevant to consider the statutory framework and purpose behind the provisions, and that the Upper Tribunal failed to do that. However, the First-tier Tribunal correctly assessed that.
I think, as you've just suggested, ground 4 may not really add anything to grounds 2 and 3, because in determining grounds 2 and 3, we'll have to look at the statutory purpose.
Yes, my lord.
And also, because this appeal is before us, we have to decide these questions. And so whether or not the Upper Tribunal judge feels not that probably doesn't matter.
Well, we would say it's a composite point that does cut through the other grounds, my lord.
But in relation to both 2 and 3, grounds 2 and 3, statutory purpose is obviously an important feature.
We don't suggest that.
So just, would you accept that ground 4 doesn't really on analysis add anything?
Only insofar as it's a bolt on to 2 and 3, my lord, so yes, because if we're right about 2 and 3, one would look to ground 4, but if we're wrong about 2 and 3, 4 makes no difference.
So I don't quite follow that. If you're right about 2 and 3, then you'll have got there in part by referring to the statutory purpose.
Yes. If the court is content with that construction, yes, I don't see to disagree. And now, for those reasons, our case that is highest is that not only was there not work for the purposes of the regulations here, but also that the money acquired cannot be deemed to be self-employed earnings. And to be absolutely clear, that is what the Secretary of State initially removed entitlement on the basis of. It was self-employed earnings. And that was the basis that the Upper Tribunal, in substance, we say, sent the matter back. So first and foremost, it is not self-employed earnings arising from work. And neither, in the alternative fallback position, do we say at its highest, is it capital, for reasons that will become apparent. Now, the Upper Tribunal and Moylan, for instance, the Secretary of State, characterise that as a fallback position. But I will explain to you why they say that that does not stand up.
I thought that they said that it was income other than earnings.
Yes, my lord, but as will become apparent, firstly, in my submission, the core of what the Upper Tribunal did was to find that it's self-employed earnings. Whilst there's discussion about income other than earnings for the purposes of Regulation 4 read with Regulation 91, our position is the only way that would work is under Regulation 105.3, which I'll come back to. And that would be earnings, which is treated as income. But for reasons that will become apparent, our read is that Regulation 92 and 91, in relation to income other than earnings, that only applies to employed earners, not self-employed. And I'll come back to why that's the case. To deal head-on, lastly, under introductory remarks, my lords.
Sorry, can you just give me that point again, just so I've got it? I haven't picked that up so far. So
yes, it's income other than earnings is the alternative basis upon which the Secretary of State says the money can be treated.
Yeah.
In terms of where that bites, our position is it cannot apply to him as a self-employed earner if we're wrong about him being a self-employed earner, because income other than earnings is expressly tied to the employed treatment of income, not the self-employed treatment of income. and I'll explain why we say that's the case. But also, Regulation 1053, which is a provision whereby capital is treated as income. 1053 says earnings will be deemed to be income in effect. And we say that that does not fit as the fallback. And it may become clearer, my lord, when we go through the trawl of the legislation. Very lastly, in introductory remarks, in terms of some comparators put forward by the Secretary of State, the kind of wants to deal front on with these. What is said is, why should the appellant, as an illegal vendor of bikes on 9 Elms Market, be treated any differently under the regulations to a person selling legally on 9 Elms Market? First, there is, of course, a substantive and qualitative difference between the two, in my submission. An individual organising their labour by way of registering for a licence, maintaining their tax affairs, advertising perhaps, management of expenditure and the like, obtaining stock. These are all facets of the legal workplace. And on any view, when I take you to it, you will see factual findings that clearly pull the appellant out of that. He was wholly incapable and only capable of illegal work, and those facets are not present in illegal work. So there's a factual distinction between the two. But of course, our position is there may well be a legal bike seller who, for all intents and purposes, is lawfully operating as a self-employed individual who may become incapable of work for the purposes of Regulation 19, notwithstanding the fact that he is in theory set up to operate legally. So, for example, were that individual to fall into addiction, and were that individual unable to carry out his lawful activities, that individual may be rendered incapable of work, notwithstanding his lawful business. And the other examples that are cited by my learned friends in their skeleton argument, you'll see them at paragraphs 55 and 58. They say a taxi driver driving drunk, they would become entitled to ESA. That is quite right, we say, because someone driving sober and lawfully operating as a taxi driver, that then becomes incapable of doing so sober, on our read, is incapable of work, for the obvious reason it cannot be right that Parliament would wish to tacitly endorse operating as a drunk taxi driver. So that is squarely within our example. That does not stack up, we say. The other example cited is an example concerning an unlicensed pub. Now that may be different, because in that example there's no suggestion of a limitation or impairment, there's no suggestion of addiction, alcohol or drugs, and of course organising an unlicensed pub may well have the characteristic more akin to the legal workplace than the illegal workplace in terms of the level of organisation. So it's factually distinct and does not stand up as a comparator, we say.
So is your submission that it depends on why you're working illegally?
Yes.
And I'm using the word work because I can't think of any other work
Yes.
to describe any other word that describes it. So you're saying if you're working illegally just because you choose to do so, but if you're doing it because, so you say you have an addiction or somehow or other you are unable to work legally, I can't actually quite see why that would happen, but that's your distinction.
Yes. Context is crucial in relation to these provisions.
So driven to work illegally. So what?
Yes.
And you're saying that's what the First-tier Tribunal's finding was.
Well, yes, my lord, and you will see when I come to it. But of course,
Okay.
there is a conclusion that his previous business, lawful as it was, went under, to paraphrase, because of his circumstances.
I understand that, but people don't necessarily turn to illegality simply because of circumstances.
No, but in this instance, that he did, and the question is whether or not that would disentitle him.
So are you saying the cause, the reasons for a person working illegally are a relevant part of the decision-making process?
The reasons and context, yes, my lord. As they apply to claimants on the basis of these findings. And in terms of the other counterfactual cited by
So if you were just engaging willfully in illegal activity, work, and getting illegal income, then you would be within the scope of the regulations in the sense that it would be taken into account as work and it would be taken into account as earnings or income.
Our position is that there is no consideration of illegal work within the provision.
At all?
At all.
Okay, so,
However,
yes,
specifically insofar as this applicant or appellant is concerned, the circumstances are very relevant to whether or not this court wants to interfere with the findings. So our case at its highest is it has to be legal,
okay,
but even if we're wrong about that, the circumstances are relevant to a consideration, i.e. was he capable of anything other than what he was doing in the context of his depression and in the context of his addiction?
Yeah, you have to argue that somebody without any jury points or mitigation at all would also not be caught, because your principal point is that this excludes illegal working, full stop. So the jury points / mitigation are your fallback.
Indeed, correct, my lord.
But just on the example you gave of the pub, I didn't quite understand whether you really had an answer to their case on that. That the unlicensed pub, I think you said that that work would fall within the definition of work in the regulations.
The distinction with that and the complexity might arise with levels of organisation and with some of the trade authorities. But of course, no, as my lord mentioned, our case is that that would not be, insofar as the high point, as in no illegal work can fall within the provision. But the fallback position that my lord cites, that would be the distinguishing factor in terms of an individual without the same circumstances operating a pub illegally. But in any event, that does not affect, we say, our core proposition under grounds 2 and 3.
Something that's is quite topical is there are said to be lots of shops selling illegal tobacco at the moment. Take a case like that. Do you say that the person who's running one of those operations where they're making the tobacco, they're putting it in packets, they're selling it to members of the public, do you say that they're not undertaking work?
Insofar as what ESA is seeking to do, it is important to say the only reason that this would bind is if there is a question as to capability to work. So it would matter what the context was to that organisation. But yes, our case at its highest is that illegal work does not come within the provisions. But if we are wrong about that in the context of Appellant and his circumstances and the purpose of the regime, that would be the distinguishing factor in the alternative, i.e. he's doing it because of his other impairments, physical or mental. And levels of organisation do come into that, but that will become apparent when I address you on some of the authorities. That being said, in terms of the decision and the criticism of, well, again at paragraph 58 Moylan first skeleton, the state regulates for illegal outcomes, so that the example of the Health and Safety Executive is cited, or the Bar Standards Board addressing criminality. Our distinction is this: post facto investigative duties, legislating post-crime, perhaps PACE, for example, that's different. Of course, the state says something might have gone wrong, and we extend our jurisdiction into regulating outcomes and perhaps any sort of consequence. That is different to our case here, as what is intended by the relevant provisions in terms of an entitlement. Well, you will have seen an ancillary point is raised before I go to substantive decision about the case of MOC in this court. I'll come back to it. It's the point about what was or was not. I don't know if you want to think.
Really don't think we're going to get involved.
It's in the skeleton.
It's not before us. No, absolutely not.
Insofar as it being before you, my lord, all I would say is it of course was in permission and cited in permission, but yes, it goes as far as it does.
Yeah.
I don't think it's anything more than you said on that.
Right. Thank you.
The initial decision, my lords, moving now to some of the conclusions. If you are in the core hearing bundle,
Are we still under introductory remarks?
no, I'm now moving into addressing you on the factual findings, my lord.
Right, the second was going through the statutory provisions.
Yes, so factual findings within introductory remarks, my lord. I'm not yet coming to the statutory provisions.
Right, okay.
So if you are at page 87 of the core bundle,
I sort of thought there was a much longer decision because there were references to other elements of it. Is this it?
this is the initial letter dated the 19th of April 16, outlining the decision.
Right.
I think that you're probably right, my lord, in terms of whether or not there is a longer decision behind it.
Yes.
Be correct to them if I'm wrong. From our point of view, not much turns on that.
Okay.
The only reason I go here is just to make clear the initial change of circumstances decision, as far as it goes, concerns this 19th of April 16 decision, and it was made on the basis of self-employed earnings which exceed permitted work limits. So just to make good the point, the original removal of entitlement was solely on the basis of the consideration that he was doing self-employed work amounting to self-employed earnings.
Mm-hmm.
Then to the first-tier tribunal decision, my lords, and you have that beginning statement of reasons at tab 10 of the core bundle.
Yes.
Just to touch upon certain conclusions by Tribunal Judge Vine, dated the 3rd of May of 2022, you will see at paragraph 2 on page 83, again, just driving the point home, recognising the basis of the removal of entitlement pertains to self-employed earnings. And of course, paragraph 4, you have the second overpayment decision that was made consequent upon decision 1, which saw that there was a recoverable payment of 9,840 spot 50 for the period of 1st of October 14 to 5th of April 16. So 2-year period is what we're dealing. And over the page, my lords.
Sorry, can you just tell me, if you look at the first 3 paragraphs of the OTT, it says that the first decision was the 8th of April. Done so on the basis that his self-employed earnings work exceeded the permitted limits. Tribunal decided he was not working, as such the tribunal he remained entitled, allowed the appeal. Second decision, 19th of April. So there were 2 decisions that were being, is that right, that were being appealed?
Yes, which is why I cite them, my lord. So you have decision 1, which is you're no longer entitled. So that
Yes.
is 8th of April of 16.
And the second one is you've been overpaid as a
Yes.
result of not being entitled. I've got it.
And
Okay.
of course, that is because I don't think it's in dispute. For all intents and purposes, he was entitled to ESA, but for the
Yep,
discovery.
okay.
Yeah.
I understand. Thank you. Yep.
In terms of some of the factual findings we say matter, my lords, over at page 84,
Yes.
you will see the tribunal at 6 and 7 were alive to what they were looking at, as it were.
Yes.
But particularly, I draw your attention to paragraphs 8 and 9. The extent of the addiction at 8, you will note, referred for assessment, suffers from long-term depression to the extent he was required to attend a treatment centre for the addiction, and he attended for 3 weeks, and then provided with a support worker and placed in supported housing. And I draw your attention off the back of my lord's question. He's lost his previous council flat through his rent arrears due to having lost his business due to his addictions.
Yes.
So previously incapable of sustaining a legal job.
So that's not what it says,
Well,
does it?
that's what we rely on to make that submission.
Well, that's not what it says.
Well, it does say, my lord, his rent arrears due to having lost his business due to
I
his
know, but it
addictions.
doesn't say he was incapable of work due to his addictions.
All I infer from that, my lord, is to say if he loses a job because of his addictions, and that job is legal, and then he is only then capable of doing an illegal job, we infer therefore.
Sorry, I don't see that at all.
It's simply to say we infer from this, my lord.
I know you're saying that,
Yeah.
but I'm sorry, I'm saying I don't see how you can infer it, because all it says is he lost his business due to his addictions.
Yes.
It doesn't say, and he was incapable of work because of his addictions.
I only seek to say the decision as a whole off the back of the subsequent conclusion, my lord, when it is found that he's only incapable of legal work and consideration is that he's only doing illegal work, you would be entitled to conclude, therefore, he was not capable of doing legal work previously. But
This all goes to the fallback argument anyway.
yes, indeed, my lord has
It's
that,
not
yes.
front and centre.
No, but
The jury points are not front and centre to your case. So if you're wrong on the main points, the interpretation points, then it's going to be debatable the extent to which any of this actually is going to matter.
agreed. But I only go there now to avoid going there later.
Okay. Thank you.
And you have at paragraph 9 the outline of his circumstances there. In terms of that link, fund his addictions by engaging in criminal activity, first sentence of. So we accept his findings are there, of course. And then you have at paragraph 11 on 84 the conclusions about the money, as it were.
Well, yes, I mean, 30,000 went through his accounts. I assume that means bank accounts.
Yes.
Between October 14 and 15. Yes, okay.
Over the page, crucially, and as
So
my
we
lord-
can infer that, can we, that he was, because he was receiving cash in hand, that he was made more than that.
Well, I would be cautious about that, my lord, given
Right.
what we don't have and what
No, we don't. Thank you.
is the actual account. Over the page at 85, paragraph 30,
13.
paragraph 13, 1-3 on
Yes.
the top of 85. If you cast your eye over that.
Yes.
So
I'm not making my lord's point, but when I got the money, I spent it. I didn't loyally put it into the bank.
yes, but it's fallback position such as it is. It's just to simply make it that the tribunal was of the view and accepted as evidence that he was spending almost immediately, and crucially, the penultimate sentence there, he was not fit to do anything other than feed his addiction. He was not fit to work. I simply say these are findings of fact made by the First-tier Tribunal, having heard evidence.
How does that fit with the description of activities? That he was buying and selling bikes in a market and online, and he was making at least £30,000 a year out of it.
Well,
How do those findings fit together?
it is, of course, first and foremost in the context of the illegal marketplace that we say Parliament can't have intended. And what the First-tier Tribunal rightly did, we say, is conclude, and it might assist to then go on. If you are at page 86, my lord.
Yes.
You have specifically at 18. The point being made there is that there may be a lack of reference to illegality in provisions, but nonetheless the tribunal were of the view that the operation here did not fall within the statutory provision. And paragraph 20.
But that's a different point. My concern is we're in danger of muddling together these 2 points. My lord asked you how the finding of fact about fitness to work fitted together with the earlier findings that he was running the stolen bike business both in a market and online. How, as a matter of fact, do those 2 things fit together? regardless of what statutory provisions may or may not say. Just as a matter of fact,
The tribunal quite clearly took the view that notwithstanding what he was able to do, so the selling of bikes and receipt of the money, notwithstanding that, they took the view that they could not find, factually, that that amounted to work. Now, I appreciate the court's concern to say, on the one hand, well, if this sounds like legal work, then how can they say he's incapable of doing it? But the First-tier Tribunal was right to consider that, in effect, the level of organisation in the context of illegality is just not work. But I appreciate the tension in the findings, but we say ultimately it is correct as a matter of a read of the provision.
I mean, it seems as though the tribunal's real reasoning was in 16, where it says selling bikes illegally is not work, rather it's criminal activity, plain and simple. So the tribunal seems to be saying that if you're doing something criminal, it cannot be work.
Yes, the primary position.
And therefore, when you look at his findings about whether this man was working, it's all fed by that underlying point, isn't it?
Yes.
It cannot be work because it's illegal.
Yes.
So the findings he makes aren't in fact pure findings of fact. He's really saying, I don't think this person could be treated as fit for work because he was a criminal. Or rather, what he was doing was criminal.
Yes, and in that sense, I think my learned friends agree, and I did sort of set out question of mixed fact and law, my lord, and that explains the tension. And appreciably, yes, our case is as high as you can have the point. I take you to some of the circumstantial findings for the fallback position, but yes, the tension in findings is explicable by this being both a functional, what can you or can't you do, factual assessment in the context of the legal. They are inherently linked, but we say we can still get through. That is the First-tier Tribunal decision as far as it goes. Now, the Upper Tribunal decision, the key findings, if you turn up page 78,
No. So what page are you looking for?
page 78.
Not in my bundle. I don't think. Are you looking at the Upper Tribunal's decision?
Yeah, so paragraph 29 of Upper Tribunal decision.
Thank you.
Yeah, so behind tab 4.
28, there's page 47.
Forgive me, my lord. Yes, tab 5.
Yes.
Yes.
was the claimant doing work? That
Yes, indeed. So paragraph 29 of the same.
Yeah.
Page 47.
Yeah.
Some of these findings alluded to here. So paragraph 29 and over the page, on page 48. Now, middle of sentence. Here the Upper Tribunal is talking about some of the points my lords address. In terms of the amounts, and you'll see middle of page, conclusions taken together, various activities involve sourcing bikes, negotiating prices and the like, purchases and sales, necessary repairs, dealing with customers. Those aren't findings that are extant on the basis of the First-tier Tribunal decision. So here we say, slightly off the back of your previous question, the Upper Tribunal has bolted on some factual conclusions that enhance the level of organisation.
Well, okay, but I mean, if you look at it, he must have been involved in sourcing bikes. He must have been negotiating prices for purchases and sales. And he must have been dealing with customers. So the only thing that is possibly not supported by the First-tier Tribunal is carrying out any necessary repairs.
Right.
Although that might be an inference from the fact that you're selling bicycles, that you're going to sell them in a usable condition.
Well, yeah, but in my submission, they're all inferences that aren't extant on the basis of the First-tier
I appreciate that, but apart from necessary repairs, the others are inevitable.
If you're against me on that, my lord.
No, it's not. I'm just saying. I'm suggesting to you it's inevitable, given what the claimant was doing, that he was sourcing bikes, he was negotiating prices for purchases and sales, and he was dealing with customers.
The nature and the workings of the criminal enterprise, in my submission, I think the most I can say is that speculate as to exactly what he was doing. On the counterfactual, it may well be that he was just being given them and told to sell.
He's left out that he was selling online.
Yeah, that is accepted as a
That which is quite a.
And my lords,
I also wonder whether actually what the judge is doing in this passage is not, I'm not sure that he's to be read as saying this is exactly what this man did. I think he's using it as an example, because he's given the example before of the person selling the tricycle.
It's a proxy, possibly.
Yeah.
As an example of what selling bicycles might entail.
Well, in my submission, it goes further than that insofar as the way it's tied to the claimant in this case.
Okay.
It's not the hill we wish to die on. It's just
Right.
Okay. And so, my lords, what is happening here is the root of the error, and pertaining to paragraphs 29 and 39 of the Upper Tribunal decision. This is, of course, the core of what might be grounds 1 and 2. And really, I will address this as we go, but the core conclusions really are at page 49 and 50, and you'll see at paragraphs 36 to 37, that is where the tribunal are concluding as to the points on ground 2 and the fact finding for the purposes of it being deemed work. And lastly, at 36, I mean, the Upper Tribunal, penultimate, last sentence is, the First-tier Tribunal misdirected itself by focusing exclusively on the claimant's impairment when considering whether or not he was doing work. We obviously disagree with that. We say the First-tier Tribunal was right to do that as part of the fallback position, notwithstanding the primary position. And so at 37, the Upper Tribunal, middle of page, rejected the submission that work amounts to the legal workplace, essentially for the reasons set out above, middle of. It was not for the Secretary of State to show that illegal work was included within the scope of work, rather it was for the claimant to demonstrate that legal work was necessarily excluded from its scope. We say it's the other way around. And as will become apparent, for Parliament to have intended to include, it is for the Secretary of State to show you that has been done expressly or implied.
Well, that's the key difference.
Yes.
Because when we get to it, it's silent. And so the question is going to be whether that's because, whether we decide, well, therefore it must include, or therefore it is excluded.
Indeed.
And you have the burden.
Well, in terms of was it silent on, my lord, given the nature of what would be said, if the Secretary of State's right, this is legislation peppered with reading in illegal work. And so whilst I seek to show the silence is evident,
But that's your way of putting it. You could put it the other way and say, well, there's nothing here that excludes money earned illegally.
yes,
And I think that's, in a sense, that's a single issue, and that I'm not sure. You may well be able to demonstrate that this is wrong. But when we do the trawl, I have a feeling those looking for a clear answer may be disappointed, because it just refers to work and income.
and we say that silence is enough in the context of the regime and the public policy behind regulating legal and illegal activity. We say the silence is in our favour.
And they say it's in there.
Yes, but to be clear, whilst we pose the construction of it means what it says on its face, it would have to be expressly included. The reason I suggest that the Upper Tribunal was wrong at 37 is because there's an uphill battle for Secretary of State, we say, to show that by inference, illegal work and income is included. And that's as a matter of policy.
Okay.
To the authorities bundle, my lords.
Yes.
The
Are we now going to section 2?
we are now in section 2
Thank you.
under legislation.
Thank you.
So, if you are in the authorities bundle, the Parent Act, Welfare Reform Act 2007, and if you go page 15,
Yes.
you will see there the statutory basics and the core conditions. You will note subsection 3,
Yes.
3A, is the, if you will, enabling provision
Yes.
as far as limited capability for work is concerned. And you will note also, top of page 16, subsection 4,
Yes.
you have there a provision providing for limited capability for work if it's limited by a physical or mental condition.
Yes.
But this is important, my lords. It is tied then to a limitation such that it is not reasonable to require him to work. So subsection 4A and B do two things. Is there a capability for work limited by a physical or mental condition? And is that limitation such that it is not reasonable to require him to work? We say this matters because the Secretary of State says, for example, read in illegal to that. So where work is addressed, it's legal and illegal. But it
Well,
needs
they
to...
don't ask it to be read in, they just say that's what it says.
Well,
They just say to require him to work. Work is just an ordinary word.
we say it has a specific meaning, of course, in terms of legal, as opposed to illegal. Our construction is that Parliament did not intend work here.
Yeah, you say it's excluded.
Yeah.
And you have to demonstrate that it is excluded.
Yes, and as I seek to go on to explain, if the Secretary of State is right, it needs to be inferred that by work, even if not expressly, that by work what is meant is illegal and legal, that it incorporates both contexts.
I think other provisions are probably more important.
Well, this being the parent provision, all I simply say is that for this to be right, they would have to read in or infer that Parliament intended that the limitation is such that it's not reasonable to require him to work legally or illegally.
Yes.
That's our construction here.
Thank you.
It would have to be deemed reasonable for appellant to work illegally. And that doesn't work, we say. It can't be presumed that Parliament intended that. You then come to page 25 in section 8.
Yes.
Now, section 8 is the limited capability for work provision,
Yes.
and it's just so we've gone there. 8.1, making clear again that the limitation by physical or mental condition and whether the limitation is such that it's not reasonable to require him to work,
Yes.
and then giving rise, of course.
Shall be determined in accordance with regulations. Yes.
Yes.
So it's not an abstract question, you determine it in accordance with regulations.
Indeed.
Yes.
And then over the page at page 26, subsection 5.
Let me just ask a very boring question. There have been all sorts of changes to this legislation. Are there any points about which version was the relevant one at the relevant time?
Insofar as these provisions are concerned, well, I understand not. In terms of the core provisions, they are as was at the material time.
Right. So whatever we're looking at, we can assume was the
Version in force.
version in force at relevant time.
I am seeing nodding on the other side, but I think you all agree that in terms of the core provisions, they were the same.
Right.
At the material time.
Thank you.
Over at 26 sub 5, this is the gateway that just makes clear that there is an entitlement period, as it were, while someone's assessed. The regulations provide a person to be determined whether they have limited capability to work, treated as having limited capability for work until such time as A, it's been determined, or B, he is treated as not having limited capability for work. And of course, that is the read across to what we come to for Regulation 40 of the ESA Regulations in terms of where someone entitled can be deemed not to be entitled.
Exactly. Yeah. Exactly.
Then at page 28, more for your pen than anything else, my lords, that is just section 9. It does the same for limited capability for work-related activities. So of course, that is the sort of bolt-on payment for someone that is more impaired. But that's not applied here.
Sorry, what did you say? Which section?
Section 9, page
I've got
20.
it. Yes, thank you.
It's just so you've seen it. That doesn't apply here, but it's the same provision for the purposes of the
Yes.
limited capability for work requirement.
Yes.
My lords, then to the provisions addressing income and capital, you have, if you go to page 31, you will see we go to section 17 of the 2007 Act, and this just makes clear, of course more pertaining to what is ground 3, that there are circumstances under subsection 3 where there will be capital or income that leads to a disentitlement, basically. And you will see that there can be income treated as capital, subsection 3C, and D, capital to be treated as income. We'll come back to what that means for this case, my lords, but you'll see at sub 4 there. This is in effect giving rise to tariff income. So where an individual has capital that falls below at any given time £16,000, there is in effect a sort of reduced rate according to the amount. So sub 4 is just creating a carve out for this tariff income, which doesn't expressly apply here but may be relevant later. Page 36, my lords. This is the interpretation provisions under section 24 of the 2007 Act. And just so you've seen it, you'll see at the bottom of the page, limited capability for work construed in accordance with section 1.4. Over the page at 37,
Yes.
just above first hole punch, work
Yes.
as such meaning as may be prescribed.
Yes.
Now we'll come back to that, but we say there is no real elaboration off the back of that gateway that assists the Secretary of State. It's the functional assessment in the context of what was done. Then to page 42, my lords.
Sorry, just so that I'm clear, as may be prescribed by whom?
This I think would have to be read insofar as the regulations are concerned. So you will see when we come to it, there's regulation 40, for example.
Right. So as may be prescribed in this case in the regulations.
Yes. Yeah.
It says a few lines up actually. Prescribed means specified in.
Yes. I think we all agree.
Thank you.
Schedule 1, page 42, still in the 2007 Act.
Yes.
These are the conditions under paragraph 1 to Schedule 1 pertaining to national insurance. And the point I do make here, my lords, is that when addressing this provision, earnings and discussions around base tax years, you will see it 1C, and paragraph 2 consideration of earnings based tax year, earnings derived from Class 2 contributions. The short point here is all of this language we say is consistent with an intention to regulate the legal workplace by dint of tax, by dint of national insurance contributions. That is all language, as it were, that would apply to the legal bike seller, not to the illegal bike seller. Now,
This is all to do with the contributions
yes,
condition, isn't it? Which
Yes.
is not relevant here.
it's relevant to Ground 3.
But
in terms of
This was income related benefit, wasn't it?
yes. The reason this matters, my lord, is because there has to be a consistent read across the whole regime, we say. It would be odd for Parliament to be regulating differently as between contribution based and income related.
So you say that that reference there to earnings, what?
Legally acquired earnings. And the reason we say that is I don't think it's being suggested, but self-evidently, someone working illegally is not going to be addressing themselves by way of registering for tax and the like. And so to be consistent across the provisions, we say, so for example, where this is talking about the base tax year lower earnings and sub 2 addressing class 2 contributions, that is all language consistent with the legal workplace.
Why is it not consistent with illegal?
Well, because the illegal bike seller, the appellant here, was not registered as self-employed.
That's a matter of fact.
Yeah.
Why is it not, as a matter of statutory interpretation, why would it not include illegal?
Well, because
earnings?
Parliament must be deemed to be regulating legal workplaces for the purposes of tax. And I will come back to this in the case of
Plenty of
Aiken.
criminals register their criminal operations for tax and pay tax.
Well,
If you've done as many POCAs as I have, you would know. So the mere fact that you have to register for tax must therefore mean that it's the proposition that it must therefore mean it's legal earnings is not right.
the circumstances would matter, my lord, insofar as, well, if one is talking about shell companies and the like and complex arrangements where there is a sort of a front business behind or in front of the criminal enterprise, that's one thing. I don't think it's seriously suggested in this case that Mr. Allen could have then registered himself as self-employed and then the state would knowingly wish to tax his illegally acquired income. And I should say at this point, my lords, the case of Aiken and a lot of the authorities we say would make that clear in terms of illegality in the treatment of tax.
Yeah, but my lord's point is that you're trying to use this as a vehicle for saying the legislation must mean only legal work, because you can't expect people working illegally to pay national insurance. My lord's point is many people who are working illegally or operating illegal businesses do pay national insurance. So that rather undermines your submission that the framing of the legislation means that it can only apply to legal work. So do you have an answer to that? Not by reference to this individual case, but by reference to the fact that there are many people undertaking illegal work, illegal activities, learning illegal illegal income, to whom this would apply.
The fact that some individuals may, for whatever reason, be able to register and then legitimise their business by way of tax or national insurance arrangements.
It's not legitimising it, it's just paying national insurance.
Yes, but in my submission, the fact that that might be something capable of happening does not mean, therefore, that Parliament intended, by way of this schedule paragraph 1, to incorporate that in the context of the ESA regulations.
Okay.
In any case, I don't want to spend a lot of time on this, but it actually then goes on to say what the earnings are. The claimant's relevant earnings for the base tax year upon which primary contributions have been paid or treated as paid. So this is only concerned with cases where someone has actually registered as a self-employed person.
Yes. And that matters, my lord, because therefore it is construed and to be constructed as we are regulating, therefore, the individual that has registered.
But in this particular bit of the statute, I mean, it could be that in some bits of the statute, earnings means, because you can see it from the context, it means, for example, here, the earnings on which national insurance contributions have been paid or treated as paid, because that's what it actually says. 2 actually says that. But it doesn't follow that wherever there's a reference to earnings, it can only apply to legal earnings. It's a non sequitur.
Well, we say not, because that would then create an internal incoherence between what this is regulating and, for example, what the income side of the coin is regulating. So the fact that this provision is addressing someone that is legally, we say, and lawfully, rightly registered, it would be inconsistent to say, well, in another provision, Parliament means something else.
What happens if you have somebody who's doing both?
A more complex question, right?
Working legally Monday to Friday, illegally Saturday and Sunday,
Well,
and earning more Saturday and Sunday than Monday to Friday. So it comes within this for Monday to Friday, but not. So how does that fit with your submission?
bearing in mind this only comes in if someone is already entitled. If someone is able to work 5 days a week in the legal workplace, more likely than not, a first-tier tribunal would find them capable of work.
Okay, 2 days and 5 days illegally.
Well, again, that would be the question of fact, my lord. I mean, if
No, we're talking about a matter of interpretation. You say that this supports your submission, that because it's referring to somebody who's paying national insurance on relevant earnings, it must mean that it excludes, the legislation excludes illegal earnings. But I was just saying, if somebody has both, you only look at their lawful income and you completely ignore their illegal income?
our case,
On your submission, yes.
our case at its highest has to be yes.
Yeah, yes.
And notwithstanding that, of course, the circumstantial for that point might apply, because in your counterfactual, for example, as I said at the outset, the legal bike seller may, for all intents and purposes, be registered for tax and registered for a license, fall on harder times, for example, fall into addiction, and nonetheless those mechanisms would be in place. He may still be incapable of work under the first question.
Well, every fourth bike might be a stolen bike, and they might know that. Every third bike might be a stolen bike, and they might know that.
Well, it would obviously depend on where it sits within that threshold, but it's simply to say the construction of the statute has in mind, we say, the legal workplace, by way of this.
What I'm seeking to sort of seek your help on is it's requiring quite a sophisticated exercise to distinguish between legal income and illegal income, legal activity and illegal activity, because it might all be mixed up together. As I say, different days of the week or within the same business. As my lord said, somebody might be selling tobacco under the counter or alcohol under the counter, whatever it might be. And you say, no, we're only going to look at what you've earned lawfully, we're going to ignore everything else. And that's your submission.
In terms of the income provisions, it would have to be at its highest level.
Yeah. Thank you.
Now, I should say, of course, the trawl, as far as it goes, has only partially started. Whether or not it may be capital, different question, which I will come back to.
No, it's all right. You're the trawl has only just started.
Well, yes, I'm conscious, yes.
I'm crazy.
I'll say that's a low moment.
You better get on with the trawl if you don't mind.
Very quickly then, as we are here, just to turn up page 3 and some relevant provisions from the 1992 Act.
Sorry, nothing more in this.
Not in
Act.
relation to para 1, I will be coming back, but it seems right to read across
Okay.
now.
Sorry, where are we
If
then?
we go to page 3,
Yep.
this is relevant because the Social Security Contributions and Benefits Act.
Yes.
Now, you will have seen that part of this case pulls in 1992 Act provisions and then there's a read
Yes.
across. It's just to say that employed earner here makes clear gainfully employed either under a contract of service or in an office,
Yes.
Q1A, self-employed earner, person gainfully employed otherwise than an employed earner's employment. So simply put,
Yes.
gainful employment under a contract of service would necessarily be a legal contract of service, we suggest. And B, self-employed earner, gainfully employed, that must be read as an individual that's lawfully employed, because otherwise, this is a provision that's suggesting gainful and contracts of service that are otherwise illegal would, in some sense, be effective. And so
But that's just a submission. It's not a.
it's our construction of it.
Yeah. All right.
And there is a read across there more for your pen. We'll come back to page 77 in the ESA Regulations.
Okay.
And just at page 7, whilst we're here,
Yes.
also relevant in this appeal, you will see section 3ABI of the 2007 Act references section 3.2, and this is the earnings and earner provisions. And crucially for this matter, earnings include remuneration or profit derived from an employment. Earner shall be construed accordingly. You probably have the submission. We construe that as denoting remuneration or profit from an legal employment. And for the same similar reasons of language. I make the point in passing, just to give the submission here at page 8, overview. Subsection 4 and 5 of section 3 of the 1992 Act, language pertaining to companies and directors of companies. Again, short point, my lords, but it's just all consistent, we say, with what would amount to the legal workplace and legal organisation. Can it be suggested that that would be denoting an illegally run enterprise with some sort of illegal director?
You don't expect Parliament to regulate, in this sense, illegal work.
No.
But yes, I mean.
Okay, but it's just to say the read across, this is not just about the 2007 Act and ESA regulations, this is also about the 1992 Act provisions, which we say must all be read consistently.
Yes.
And so you have our submission on that. Then to page 11.
Thank you.
You have here the 1992 Act section 122 interpretation provisions.
Yes.
Now, over at page 12, important for this appeal, first hole punch, employed earner, meaning attributed by section 2, employment includes any trade, business, profession, office or vocation, and employed has a corresponding meaning. I go there because, of course, our position is that that pertains to trades and businesses of a legal nature and quality, not illegal nature and quality, and I'll come back to why that is relevant.
Yes.
Now, back, my lords, to the 2007 Act before a canter through the regulations. If you turn up page 44 of the authority bundle,
Yes.
you have the second conditions as they are, and again, it's just more for your pen. We make the point that in terms of those earnings factors and the tax years, I just drive the point home, and that again is consistent language with our case and not the Secretary of State.
Yes.
Over at 45, just to sew it all together, 3 sub C and D, those are the read across. You see there, C, earnings construed, section 3, 4 and 12. That Act is the 1992 Act. An earnings factor is the same. So that's why I take you across them, I was just to hinge.
Yes. Thank you.
Now 47 and 48 fight, of course, here because we move to the provisions concerning income-related allowance. At 48, important for this appeal, the conditions are, particularly E, is not engaged in remunerative work. So these conditions, in effect, amount to a disentitlement. You can't be engaged in remunerative work. Now, unsurprisingly, my lords, we say that remunerative for the purposes of our appeal.
Sorry, wait a minute, I've got lost. Where are you?
Page 48,
Yes.
6 sub E.
Oh, got it. Thank you.
So that is the relevant definition. Remunerative, we say, must be read consistent with earnings, self-employed earnings, i.e. legal, not illegal.
Why?
Well, simply because it would be odd, again, for Parliament to legislate differently for remunerative work as compared to income and earnings. It's either we're either wrong about everything or right about everything. Is our position.
But is little a relevant here, or is that not?
Well, it would in terms of the basis of the decision, my lord, yes. Because, of course, the part of the decision is not only were you self-employed, your earnings were above the limit, so yes. That's relevant to the decision.
But isn't it also relevant to this exercise? Because that just says if you've got an income, it's a means test, isn't it? It's saying if you've got an income above a certain amount, then you can't claim the benefit.
Yes. The only reason I didn't run it too much on was I've already taken you to that's the basis of the decision. So yes, that is.
But that's also important, isn't it, for the purposes of interpretation, because it's just talking about an income. It's not even tied to remunerative work.
But again, income must be read consistently. So again, there would be a tension within that for income to be inclusive of illegally acquired income, but remunerative work to exclude it. So we say it must be read consistently.
But they're two different things, aren't they? I mean,
yes.
E is narrower than A, isn't it?
But remuneration must lead to income in certain circumstances.
Yeah, but income, need not be remuneration.
Well, on these facts, the conclusions were of the Upper Tribunal.
I know, I'm not talking about these facts,
okay.
I'm talking about the statute.
Yes, well there may be circumstances in which there is income that does not amount to remuneration. For example, a share dividend, perhaps.
Yeah.
So we accept that as a matter of construction, but we would still say, for example, a share dividend from a criminal shell company is not envisaged by the statute. So if there is income of a different kind that does not arise as remuneration, our top line point is it does not relate to the legal work.
Okay.
We then come to the ESA regulations.
Yes.
Now, if you see at page 60, my lords, this is the carve out for a lack of entitlement because of doing work.
Yes.
And so the question then, and I should take you to 52 as well, page 52 in Schedule 2.
Yes.
This is, of course, the limited capability for work assessment provision. And what that does is give rise to circumstances in which an individual has limited capability for work and allows Secretary of State under C to, in effect, reconsider the position. So that's the gateway for claimant here. Now, and then a skip through, my lords, to 74. You have there the regulations themselves beginning.
Yes.
And then more for your pen, just to tie it together, page 77. You have the read across there, second hole punch, employed earner, you'll see, construed with section 21A of the 1992 Act on Employment, including trade, business, profession, and the like.
Yes.
So that's the hitching together. All must be read consistently, we say. 83.
Yes.
Second, very top addresses certain definitions of qualification, but second hole punch, you'll see remunerative work on page 83.
Yes.
That addresses regulation 41 and 42, and below the second hole punch on 83, crucially self-employed earner. So that's the construction that would apply here. The section 21B 1992 Act definition is the read across under the regulations. That is what applies to appellant according to Upper Tribunal. Then on to page 94, my lords.
Yes.
Crucial as far as particularly our ground 1 is concerned. This, of course, is the determination for limited capability for work. So this is the link back to section 1 of the 2007 Act. And we say again, for the Secretary of State to be right, it would have to be interpreted as it being reasonable to require the claimant to work illegally in his circumstances. But our read of Regulation 19, when it talks about the assessment within Regulation 19, that is the functional, factual side of the equation. What can someone do and what cannot they do, or what can't they do?
Yes.
And then, of course, here we have the mixed question of that fact and the law, where the tribunal found this is what he's capable of, but he's only capable of it in the illegal setting. So that's the Regulation 19 test. We say it would be unreasonable to require, this is the wording, to require the appellant to work as he was. Unreasonable to require him to work illegally in the context. And
It doesn't say that, it just says, is it reasonable to require him to work?
Yes, well, the use
It's
of
obviously not going to say, I mean, it would be ludicrous to suggest that that could ever be read as saying, is it reasonable to require him to work as a criminal?
well, quite, my lord, but on the facts of this case, what it is saying, the analysis under 19 does say, top hole punch, my lord, whether a claim is capable of work is limited by physical or mental condition. If it is, whether the limitation is such that it's not reasonable to require the claimant to work.
But that's not the bit of the regulations which the Upper Tribunal based itself on. They based themselves on the bit of the regulations which says that where someone is actually working, they're deemed not to fulfil this definition.
Yes, that's the Regulation 40, which I come to, but first and foremost, and this is our ground 1 point, what the Upper Tribunal did is interfere with a correct analysis under Regulation 19, in that he was incapable of working. And then, I'll come now to one.
Incapable of working,
Within a
selling bikes illegally.
Yeah.
But he was.
Incapable of working, selling bikes legally.
But he was selling bikes illegally.
Yes, but legally, my lord. So it would have to be, for this to bite here, Regulation 19 would have to
We're
be
talking about whether somebody was fit to do something.
yes. Whether or not he's fit.
And this comes back to the point about the two market stalls side by side.
Yeah.
There's no difference.
We say there is because he was not fit. And again, it goes to our top line point. In this assessment of Regulation 19, what this is doing is what can someone do or not do because of a mental or physical limitation, and would it be unreasonable to require them to work in that context?
But it was clear that his mental difficulties didn't prevent him from working selling bikes, because that's what he was doing.
Yes, but it goes back to our top line point that it cannot be right because it would be reasonable to require them to do that illegally.
That's, I think, turning it round. But should we go on?
Yes. And on to my Lord's question at page 100.
Yes.
This is then the disentitlement provision.
Yes.
Regulation 40, treated as not entitled to ESA in any week that an individual does work. So our position is the Regulation 19 assessment correct and incorrect to apply this to the appellant in these circumstances. Because appreciating what the court's concern will be, but yes, our point is on 41, where it is saying treated as not entitled to employment and support allowance in any week in which the claimant does work. Of course, you know what my submission will be. That must be taken to be the legal, not illegal workplace. And that is because also 2G does provide, there are carve-outs here under F, forgive me, my lord.
Right.
2F, categories of work under Regulation 45 that's exempt.
Yes.
Now the Secretary of State says, well, if Parliament wanted to exclude illegal work, then they would have expressly done so by way of 42F. We say that that is not right because of the statutory framework I've already addressed. What would have to be done is the other way around. It would have to be expressly included as a form of work.
Now, all the legislation is addressing legal. You want to encourage people to go back into work and by work and in legal work. What section, was it paragraph 10 of Schedule 2 said, is that regulations may prescribe circumstances in which a person is treated as not because he is doing work. And this is that regulation.
Yes.
So are those the two core provisions?
Yes. They are
And the rest is trawling.
The rest is trawling, but the reason the trawl is necessary is for consistency in my submission, my lord, but also to address the income provisions as the ground 3 point. But yes, insofar as crucially grounds 1 and 2,
yes,
the core provisions are Regulation 19 and 40. It seems necessary in my submission to take you through the background.
And your simple submission is that work cannot include illegal work.
Yes.
Of any nature, of any description, of any amount.
In the context of the 1992 Act and in the context of the 2007 Act, read with 2008 regulations, yes.
So going back to the example I gave before, if somebody is working both legally and illegally, you take into account his legal activities, but you ignore his illegal activities, and you have to separate them out.
Our case at its highest would have to say yes.
Yes.
And that would be a question of fact.
And why would that be Parliament's intention?
Well, because it then drives to a question of what overall would otherwise be the outcome. I mean, if Parliament is taken as saying, we want to consider and regulate what is earnings and income from illegal as well as legal, it just cannot be right as a matter of intention and standing behind that public policy that would be something provided for by omission, by silence. And so if the corollary of that is a perhaps imperfect outcome whereby an individual does both legal and illegal work, and there are some circumstances in which that would mean there's an assessment of what someone's doing legally, and if they're over certain thresholds, the question falls away. But a tribunal may well say, if you're doing a legal and illegal job, there are circumstances in which you are incapable of work nonetheless, on the basis of you doing more illegal work than legal work. Yes, that is our case at its highest. And that is for the reason of the limited circumstances in which that would apply, firstly, but secondly, the converse, we say, would be a perverse incentive to, for example, on some of the income provisions, a criminal could offset their losses and profits and then actually access a greater suite of benefits, which I'll come to on the case. So there are practical extensions of the Secretary of State's position here that we say would create more mischief.
Can I just understand what you mean by illegal in this context?
But an act or activity amounting to a criminal offence.
So, I don't know whether it is, it might be. Is it criminal to work off the book, so to speak, and just take cash? Is that criminal?
Well, it might amount to theft, would it depend?
No, I wasn't thinking of theft. I was thinking of just working on what's called the black market. Is that a crime?
I'm loath to delve into some offences that I may not be aware of, my lord. I mean, if an individual, well, for example,
if any aspect of the work involves illegality, any aspect, then
yes,
it's
well,
excluded.
I suppose thinking it through, if an individual is earning income over a certain amount in a legal setting, and they are not paying tax on it, of course that will lead to forms of sanction. As will become apparent on the tax law authorities are quite clear in my submission. The case of Aiken is not with Secretary of State, it's with us. Tax authorities don't want to.
No, I'm not talking about that. I'm talking about what you mean by illegal.
First and foremost,
what when you say illegal doesn't include illegal work, what in your submission that encompasses?
The submission I gave, my lord, is an act or activity amounting to a criminal offence.
Okay.
And even if wrong about that, it would necessarily be some form of unlawful activity. So, for example, the case of Best, which I'll come to in adverse possession, and Nasrullah, which addresses the case of fraudulent.
Okay, sorry, yeah, thank you.
In terms of moving on, you'll see then at 103.
Yes.
Addressing remunerative work, Regulation 41.
Sorry, wait a minute. 103.
Yes.
I'm looking at Regulation 47.
You should be at page 103. And you should see
just hold on. Regulation 40, paragraph 1, says in which any week in which that claimant does work, and work in paragraph 7 of Regulation 40, work means any work which a claimant does, whether or not that claimant does it in expectation of payment. So that's the meaning of work for the purposes of Regulation 40.
Yes, and you might have seen in skeleton arguments, my lords, that our concern, if the Secretary of State would be right about that in terms of illegal work done, albeit not in expectation of payment, the point is made, and as was made before the tribunal, that might include someone working in circumstances of modern slavery and or servitude, who in the course of that does offending, will never be paid for it. If illegal work is incorporated, doing those things absent expectation of payment would amount to work, which would disentitle that individual from ESA. It's an ancillary point, but just to say as a matter of construction, we say that can't be right.
But the words are any work which a claimant does. Any work.
Yes.
Okay. So you say any legal work.
Yes.
Right.
And more has to be shown in order for that to be incorporating illegally.
Well, that's the question. Do you see any work? It means any work. I'm suggesting that you're the one who's trying to incorporate additional words by limiting it to legal work.
By way of intention and inference, yes, we say that it cannot be right. For example, the heading of work not done in expectation of payment, a reason why we say that cannot mean what the Secretary of State says it means is that example of one slavery. So someone may do an activity that amounts to a criminal offence, they will never get paid for it if they're in circumstances of servitude. It cannot be right that that would amount to work disentitling them from the ESA.
Thank you.
But they'd have a defence in criminal law, so they wouldn't be convicted, so they wouldn't have undertaken a criminal activity.
Well, my lord, the separate debate, but there are times, of course, where individuals that have been trafficked are
Well, I'm sorry. I'm simply dealing with your justification by saying, well, this would cover people who are then subject to modern slavery and they could be subject to this. And I'm just pointing out a fairly obvious way where that may well not happen. I mean, it's got nothing to do, in my view, with this case.
It's an ancillary point only, my lord. It's just a matter of construction. I suppose the only thing I would say is that much like there might not need to be a diagnosis at times of a mental health condition in order for a decision maker to take into account, there might not be a conviction, but nonetheless a first-tier tribunal might find as a matter of fact someone is acting as a criminal.
Right. So you're then taking us to page 103.
Yes, 103 and Regulation 41. This is the disentitling provision. I think I've covered it simply to say Secretary of State says if they were going to carve out illegal work, they would have done it. They didn't. Our position is the fact of the read across from all regimes makes clear that what is intended here is legal, not illegal, and the absence of an exemption for illegal matters not.
Right.
And just to say, you then turn to 113.
Yes.
And this is the provision under 45, just so we've gone there.
Yes, I see.
The exempt for that.
Yes.
113. All I say on this, my lords, is again the statutory language, it all drives towards legal, not illegal. So the thinking behind these provisions, for example, in terms of charitable volunteering at sub 6 or sub 3 national minimum wage.
Yes.
This is all statutory language driving towards exemptions in relation to the legal workplace. It is consistent with Parliament thinking about legal, not illegal. Now, my lords, we then run to page 117, and that is all a lot of work done in terms of the trawl you'll be pleased to hear insofar as the 2007 Act and regulations addressing our grounds 1 and 2. But if you turn to 117,
yes,
this is the ground 3 provisions insofar as income are concerned. 117, calculation of income at 90, and you'll see at 91 the calculation of earnings derived from employed earnings and funded income other than earnings. So what this is doing, and you will remember again as we've gone to 6.1 of the Act, the conditions of entitlement point. So this was my Lord's question about income thresholds, and of course we lent in reply also on the remunerative work point.
yes,
So that's the read across. Drawing a line in the sand in terms of what we say matters concerning Regulation 91, our point here is that this does apply, you will see, income and capital, Chapter 2 income, calculation of earnings derived from employed earners' employment, and income other than earnings. On a little read, we say that applies to employed earners, not self-employed earners. And that will matter when we return to it.
Sorry, why did you say that?
Well, because it says calculation of earnings derived from employed earners' employment. Now, of course, my lord, if it's disjunctive, and if it's and income other than earnings, then I still have submissions to make on that. But there is a read of that that's contained to employed earnings, and income from employed earnings, not self-employed earnings.
What would be the policy behind that?
Well, the fact that there is, when addressing self-employed earnings, my lord, it might be more speculative, because one can imagine if I am employed, I have a fixed salary, income other than earnings may well be unearned income or prospective salary, whereas of course, if one is self-employed, there might be more uncertainty as to future income or unearned income, as it were. Now, Then if we turn to page 120.
Yes.
Now 120 addresses earnings of self-employed earnings. And simply to say there's no read back to Regulation 91 there, you will see, so that makes good our position that actually the way in which the regulations treat calculation of earnings from self-employment under 92 is distinct from employed under 91. And then you have more for your pen over at 121, the calculation of the weekly earnings under Regulation 94. Now that of course addresses Regulation 91 there. Calculation of earnings derived from employment and income other than earnings and deductions from contributory and allowance. So that's doing something slightly different. But that is addressing this calculation for 91, we say concerning employed earnings. 124, my
Sorry,
lord.
can I just understand your submission on this point? Are you saying that the only income which is relevant under these provisions is earnings?
It will be primarily earnings. Then there is a prospect of income that's treated as earnings. And then we'll come to the capital provision in 105, my lord.
Leaving that aside, leave aside the capital thing that you've described. Because just going back to Regulation 91, that refers to earnings derived from employment as an employed owner. I take your point, you're saying that doesn't include earnings from the self-employed person. But then it says, and income which does not consist of earnings. So that seems to be something else. It can't, that's clearly not earnings. So what is that?
Yes, there is a read of it. All I say that that's contained to employed earnings, but the alternative, yes, if that's disjunctive, that's a separate category that you might find would incorporate self-employed earnings.
Because if you were right, income other than earnings wouldn't be covered for self-employed earners.
Yes, well, insofar as 91 treats it, yes.
Well, but it's not in 92 either.
No.
So it would therefore be an omission. If you don't read it disjunctively, it's then not covered.
Yes, and the rationale that may be for that, as far as it goes, is the point I make about unearned income in the context of employed contracted employment and self-employment in future work. I mean, unearned income might be taken to be, as I say, an unpaid salary. That would be distinct if one was self-employed, of course. But as I will say, even if that's not the case, because of the way in which the capital might be treated under 105, it matters not, and I will come to that.
But that involves us not reading and disjunctively.
Yes.
And if you read and as disjunctive, then this particular point doesn't arise.
Yes, there's one or two interpretations I accept. It's one or the other.
Yeah.
So I'm still a bit, I'm sorry, I'm sorry, I'm being a bit slow. I'm still a bit puzzled as to what your submission is on this.
There is a read of 92 that contains it to employed.
But what's your submission rather than there is a possible reading?
Well, first and foremost, that is a read of it that we would suggest.
Which is?
That it's contained to employed earners and employed earners unearned income. And that is because it expressly addresses calculations of earnings derived from employed earners' employment and income other than earning. Well, I accept, though, there's an alternative interpretation that.
But so it's confined to employed earners, other income.
Yes. That's one read of it. That's what we say first and foremost. Alternatively, we accept it. Therefore, income other than earnings may well also include self-employed earnings. 124.
would income other than earnings, you gave one example earlier, it would include dividends from shares, for example. And do you accept that income other than earnings would include such things?
It may well be, yeah. Page 124, you have the earnings of employed earnings that's addressed,
Yes.
and that is under Regulation 95. Short point, conscious of time, my lord, it's simply just to say again what Regulation 95 provisions in the context of employed earners does. It is all addressing the legal workplace. So those are features and components of the legal workplace. 95(1)(a), bonus or commission. Pylon, payment in lieu of notice, holiday pay, arrears. So it does, in my submission, drive towards what might be deemed the legal workplace. 125, yes, and so at 125, you see sub 4, compensation payments are addressed. Again, of course, it would not be right in my submission that Parliament had in mind here criminal bosses being taken to the employment tribunal by those that work as part of their criminal enterprise. It's just to make it that this is another example, we say, of language consistent with regulation of legal, not illegal. And then 128, my lords. And Regulation 97. Calculation of earnings of self-employed earners. You'll see at 1, gross receipts of employment and any allowance paid under Section 2 of the Employment and Training Act. The Enterprise and New Towns Act 1990 is addressed. Once more, simply to say that we say would fall within the legal, not illegal workplace. And then lastly, insofar as the earnings provisions are concerned, for self-employed individuals at 129, or for your pen, you will see there the calculation of net profit of self-employed earners. My lords will perhaps preempt what I'll say about this, but the net profit and those sorts of calculations, we say, must denote legal workplace by dint of those individuals being licensed, accounting for their expenditure, offsetting profits and losses. Perhaps they have an accountant. Legal, not illegal. Now, lastly on this, my lords, insofar as Regulation 105 is concerned, before I turn to my third and final...
Can you just remind me, is there any definition in the regulations of income?
Not expressly,
no.
My lord.
Okay.
And that does drive to some of the points I gave to you shortly at 137.
At 137?
137.
Yes.
You'll be pleased to hear this is the end of the legislative tour.
Thank you.
137 and Regulation 104.
Yes.
Calculation of income other than earnings.
Okay, thank you, yes.
So what this is doing, and it does reference 91, calculation of earnings derived from employed earners' employment and income other than earnings, you have our submission on that. The income of a claimant which does not consist of earnings to be taken account will, subject to 2 and 7, be gross income, and any capital treated as income under 105.
So this is a sort of a definition of income, or it's treated as income.
Well, something treated as income,
Yeah.
Yes, it's a sort of carve-out. Our position, first and foremost, is that our case is as highest, of course, is that in terms of the two options there, gross income and capital treated as income, for reasons I've already said, gross income and capital denote legally acquired, not illegally acquired.
Right.
But in terms of an assessment of what gross income might be, gross
Yes.
income might then be, for example, an unearned income over a period. But in any event, that is going to necessitate a calculation of what is gross and what might be net. And again, that is just consistent with the legal offsetting of profits and losses. 105, which you have at 141.
Yes,
This is capital treated as income.
yes.
We say first and foremost reasons I already said this would not apply in terms of regulating an illegal right now. But if 105.3 was to apply, any earnings to the extent that they are not a payment of income are to be treated as income. Now, somewhat circular perhaps, but what Secretary of State say is their fallback is, well, if this is not self-employed earnings, it's earnings other than income under Regulation 91. Now, in their skeleton at 69, paragraph 69, page 169 of Call Bundle, just for your pen, it says this: the mechanism in 91.1 and 104 creates the category income which does not consist of earnings. That is, substituting the relevant authorities or definitions, income which does not consist of any remuneration or profit derived from any trade, business, profession, office or vocation. And they say there's no express or implied restriction in that category. Firstly, bearing in mind this is the fallback, so what Secretary of State says here is it's income other than earnings under 91, even if it's not self-employed income under 95 and 6. The fact that that would suggest it does not consist of any remuneration, that cuts across firstly Regulation 40, because Regulation 40 says it's remunerative work that disentitles. So on the one hand, if it is the fact of doing remunerative work under Regulation 40 that removes an entitlement, it cannot be right that then 91 applies by way of income not consisting of any remuneration. Those two things can't be true at the same time, we say. And secondly, if 105.3 applies, reading in that to the Secretary of State's substitution, it would be as follows: earnings treated as income which does not consist of any remuneration or profit. So that would tie together what the Secretary of State says about 91 with the application of 105.3. We say that that cannot be right. Earnings treated as income which does not consist of remuneration or profit derived from trade, etc. It would make no sense to say on the one hand there is earnings, but it is not remuneration or profit. And so it cuts across Regulation 40 and it doesn't work.
Well, it's a separate argument, isn't it?
I
mean, they say that they're right on Regulation 40.
Yeah.
But they say that if they're wrong on that, so you win on that point, there's still a separate ground, which is to do with income, as I understand it.
Yes, and I
So it's an alternative argument.
yes, in fact, my lord, I did say it's their fallback position, and I just say that on their fallback position under 91, we say it cannot work for those reasons. And in any event, my lords, insofar as the Upper Tribunal was concerned, the Upper Tribunal did not entertain capital in any depth at all. It has its
I'm not sure it's anything to do with capital. But I thought they were just saying, okay, he's received all of this income,
Yes, but of course, what the Tribunal did say is...
which is a finding of fact.
Yes, but what we're saying is if we're wrong about everything and the Secretary of State gets through on the point of it being this earnings, income other than earnings, it's just a fallback position to say even on their case it can't be income other than earnings because 105.3 does not read with what they're saying concerning
But
that provision.
that says that any earnings, to the extent they're not a payment of income, that means presumably earnings which, for whatever reason, are treated as, would otherwise be treated as capital, are to be treated as income. That's all that's saying, isn't it? It's got to be an earning. But the hypothesis here is that the money isn't it's not an earning from work, £30,000, but it's still income because he's received it. That's as I understand the argument. It's quite a simple point.
Well, yes, but the way in which it's constructed is to say that the wording's then read together, and it might help to go to Coulson on page 169 and paragraph 69 of Skeleton. The Secretary of State says the way they get there between Regulation 91.1 and 104 is as follows. Regulations create the category income which does not consist of earnings, that is, parenthesis, substituting in relevant definitions, income which does not consist of any remuneration or profit derived from any trade, business, profession, office or vocation. They then say there's no express or implied restriction such a broad category. It's not clear why this would not apply to the £30,000 required. Now, I appreciate this is the fallback. You have my submission on this. There's tension here between Regulation 40 and remunerative work, because their construction would exclude remunerative work. But secondly, our position is that if one looks, the only way that would fit, if it's not to be treated in that way, would be 1053. 141, page 141. Capital treated as income, any earnings, to the extent that they are not a payment of income, are to be treated as income.
Why is it capital?
Well, because
At all? Why are you in that provision?
Well, because
They just say that it's £30,000 which was received over the period of a year. That's income.
Well, because in my submission, 1053 is the only way they get there, and that's alternative. My Lord's case law.
Yes.
Firstly, the context and purpose. You would have seen the authority of Al-Hashim against Secretary of State. This is cited, and you have that at B2.5, starting at 332 of authority. Now, this is one of the only, and I'll be corrected if I'm wrong at the moment, Court of Appeal level decisions addressing employment and support allowance in any detail. We rely on this in general, my lords, to make clear that our read of the purpose behind employment and support allowance is consistent with the court's analysis in Al-Hashim as to what ESA is about. So 336, you will see that the issue on the appeal was whether or not it was a labour market related benefit or a social assistance benefit. So this does admittedly drive towards our fallback argument.
Sorry, which paragraph did you say?
So page 336.
Yes.
Paragraph 6.
Thank you.
So the question before the court, bottom of 336, and the aims there. Incapacity benefit, it's about the right support. So whether customers were capable of some work given the right support, that would lead to better employment outcomes for people with disabilities. Now, in that case, of course, the Secretary of State was arguing that it was a benefit that would take it out with the EU regime. So the court was ultimately with Secretary of State in terms of this is about facilitating access to whether or not it's facilitating access to labour market for the purposes of EU law or recovering sufficiently to be able to work. And of course, the latter is the social assistance benefit, and the court found that it was.
This is on quite a technical point, which is, does it count as a labour market related benefit or social assistance under EU law?
It's relied.
It's a very different context from the one we're looking at.
Yes, it is just to make good our points on the purpose and context of the ESA. It's accepted that what was before the court was a very different question. It's accepted, of course, this ties more to our fallback argument that the provisions must be read in their context.
purpose is about providing the right support.
Yes, my lord, and so if you turn up page 343, and if you are at paragraph 37, you'll see what the Secretary of State submitted in that case. Safety net for those that cannot help themselves. It's not about
It's a
facilitating.
safety net for people committing criminal offences.
Well, our position is on the findings that the appellant was not able to help himself by dint of his addictions and his mental health.
So he was helping himself by committing criminal offences.
Well, the appellant cannot get away from the unsympathetic fact, but
No, but I mean that the purpose of the legislation is to provide the right support for people so that they fulfil their potential. I don't see how that helps you in this case.
it's simply to make good that the court agreed with the Secretary of State's submission. It's about a safety net in the context of disabilities, and it is about the possibility of work in the future. The reason we say that is relevant is because in this case, it's about getting the appellant back into the legal workplace, not disentitling him to this benefit, such that all he's left to do is work illegally in the context of his addictions and his mental health concerns.
But he was working illegally with the benefit.
Yes, my lord, I can't get around the fact of that, but
So well, that's
yes, Al-Hashim is just authority for what the
Okay,
stands
thank
for.
you.
We say that's
Yes.
consistent with our read.
Yes.
And again, in my skeleton argument, you will have seen, I don't think I need to go to it, paragraph 31, at page 147 and 148 in the authorities on statutory intention and consideration of explanatory notes.
And 42, paragraph 42, clear from the history of ESA, primarily provided for those who cannot work.
Yes, it's red line there on page 344.
Thank you.
So you have that, my lords.
Yes.
Best, case of Best against Chief Land Registrar.
Can you remind me where that is?
That is tab B2.4, starting at 264.
Thank you.
Now, again, Best, albeit in a different context, but we of course rely on this to say that there's no principle of law that an individual must be disentitled from a statutory right by dint of their criminality. In Best, the facts were an individual who had committed a criminal offence in relation to adverse possession, and the question was whether or not, due to a change in law under the LASPO Act 2012, that criminality disentitled him from a proprietary right.
Yes.
It's just to say.
How does that apply? How does that principle apply in this case?
Well, it applies insofar as if one turns to 299, I believe. You will see that 299 will Justice Sales outline the issue. Now, yes, different factual context, but the court had in mind the tension between right under the Land Registration Act,
Yes.
and the criminal offence. Same tension here, albeit in different context. And if you turn to 309, paragraph 43, very important in my opinion.
43.
Paragraph 43 at page 309.
Yes.
In many contexts, civil rights between persons are informed by the idea they should not benefit as a result of unlawful action taken. There's also a narrower, more specific principle that a person should not be able to benefit from a crime they've committed or from conduct with features similar to criminal conduct. And that undermines the law of illegality. So, very similar principles and considerations before the court.
No, with great respect. We're concerned with statutory interpretation, as was this case.
Yes.
Nobody is saying he wasn't entitled to it because he was a criminal, full stop. It's a question of looking at the statute and interpreting that.
Yes, but this is just relied upon as a proposition of law, my lord, to make clear that there need not be a bright line rule that because of criminality, the appellant cannot retain his entitlement to ESA. Best is just relied upon as an example of an individual's civil right, proprietary right, civil right here, entitlement to ESA, not being removed because of his criminality.
Yes, okay, thank you.
What the Court of Appeal do in that case is a very close analysis of the statute and its history and the recommendations that led to the changes in the law
Yes.
and so on. They conclude, taking the fact that there were no changes made to the Limitation Act, but there were changes made to criminal law, Parliament can't be taken to have intended to change the meaning of the Limitation Act to stop a criminal spotter from taking advantage of it. But it's a very close analysis of the statute. Isn't that what one needs to do in any case?
Yes, which is why the trawl drives it was, my lord, it's done. This is a buttress submission, just to say, yes, in that case, that's what the court did.
But this doesn't point either way, this case. It doesn't tell you that either you should assume one thing or the other. It's just...
It is an exemplar of this court finding that criminality does not disentitle an individual to a civil right. It's relied upon as far as that goes. Appreciably, that's as far as it goes.
Okay, thank you.
And just to round off that point, the 318.
Yes.
You have paragraphs 69 through 70. 69, the submission made in that case about the balance of public policy considerations. Here, on the one hand, there is, and admittedly, on the clear read of the provisions we say, but secondarily, the fallback point of context, ESA, what it's about, case of Al-Hashim. The balancing of policy interests here are, of course, on the one hand, the criminality, and on the other, what is ESA intended to do? And it's simply to say that the court grappled with that in a different context here, and fell in favour of enforcing proprietary right. We ask you do the same here for ESA.
But there was a balancing going on there as between the public policy behind the LASPO legislation and the public policy behind the Land Registration Act and the Limitation Act. So there was a balancing. What's the balancing that we are undertaking similar to that?
Well, because it is, what do the provisions mean in light of what ESA is about? So the balancing is about, on the basis of that statutory context and purpose.
Yes.
On the one hand, it is Parliament has legislated to assist individuals that have disabilities back into the workplace.
Yes.
On the other hand, it is recognising the impact and the tensions around criminal and criminal and legal activity. So on the one hand, it's the bike analogy. It would have to be accepted that on our case at its highest, the legal bike seller might not be entitled. The illegal bike seller is entitled. You have that consideration as against the policy context of ESA. That individual in the context of what the statute's trying to do and his circumstances, it drives him towards the legal workplace, therefore enforce the legal rights.
Okay, thank you.
And just at 319 and paragraph 76, just to finally make good the point. 319 paragraph 76 at best, the arbitrary and capricious concern, there are distinctions there. You'll see it would involve a capricious distinction between the rules of adverse possession and the rules affecting other forms of real property. Again, different context. But here, of course, there is an arbitrary distinction drawn by the Upper Tribunal, for example, in terms of the pickpocket example. That would not amount to work for the purposes of the ESA.
That doesn't concern us because that's not this case.
No, I'm just highlighting.
We're not going to be giving a judgment that rules on which particular criminal activities might be covered.
I'm not suggesting you are, my lord. The only reason I go there is the court again was just conscious of the need not to draw arbitrary results. It has to be all in or not in, legal or illegal. What the Upper Tribunal did do is say it has to be capable of also being legal work.
It depends on the meaning of work.
Accepted.
Okay.
Very lastly, B2.7 and page 357, the case of Nasrullah. Very short point here. Nasrullah.
Sorry, can you give me the page again?
357.
Oh, okay. Yes, got that.
Just to say, this references the case of Best, and it is right if one turns to 380, the case addressing again a slightly different context of proprietary rights and adverse possession. But page 380,
Yes.
81, paragraph 81, the court there was addressing fraud in addition to the adverse possession. And
Sorry, where are you?
Paragraph 81.
Okay. Yes.
And this is the point about the scoundrel. So, at paragraph H, given that time undoubtedly runs in favour of a scoundrel who seizes his land, fences it off and squats on it, difficult to see why it should not run in favour of a scoundrel who does all that and then for good measure forges a transfer document. So in that case, there was adverse possession plus fraud, and the court still enforced the right. And again, it's just the analogy point. And you have there over at page 381 the point about illegality. It's the correct analysis of the legal provision. So even if that is an outcome, and even if some may consider it the approach of a scoundrel, still enforceable in that case, and we say would apply here.
These are cases of private law rights
Yes.
between people.
Accept that, my lord.
This is an entirely different context of whether your client is entitled to this kind of benefit in these circumstances. It seems to me it's an entirely different set of considerations.
They are applied only by way of analogy, my lord. It is accepted, the context is different. It's just the policy of criminality need not disinvite it. The cases on trade cited by my learned friends. The case of Hackey, but I think it's probably right, I'm conscious of time, if we just cut straight through to the case of French on this issue.
Right.
Page 348.
I'm going to ask you a lot of questions.
Not at all, my lord.
Sorry, 348.
348.
Thank you.
Now, this is relevant, and we say especially relevant in this case, because of course what's happening is the 1992 Act provisions are being addressed, albeit in a different context. So at 348 you have at paragraphs 4 and 5.
Yes.
The factual background there, we're dealing with a professional card gambler, sole source of income for last years has been gambling. You will see £30,000 per year, so similar, same amount, and net expenses, net amount to 23,200. Level of sophistication in that case was deemed not to amount to meeting the relevant provisions. And that matters in this case, because if one turns to 349, you will see the statutory scheme there, and it's more for your pen, my lords. This is pulling in at the very bottom, paragraph 15, the section 21B 1992 Act definition.
Yes.
You can see what the appellant says about this. This case found that this gambler did not meet the definition of a self-employed earner. By dint of the fact that he was not organising himself in a trade sufficient to meet the text. Now, the Secretary of State relies on this the other way, but we say that this is entirely on all fours with our case, because the same root definition is relied upon as part of the ESA Regulations, as is section 1221 of the 92 Act in terms of this trade, profession, office or vocation. They must be read together, and so when one turns to 353, if you're at 353 in paragraph 20,
This is a assessment of the facts
Yes.
of the case, evaluation of facts.
It is.
And it's just dealing with the particular circumstances and saying he didn't meet the statutory test.
Yes, but our case is that the Upper Tribunal applied it incorrectly for reasons that I'll come to. So if you're at 353 in paragraph 20, just to be clear, these authorities were relied upon by the Upper Tribunal to say this interpretation of section 2 of the 92 Act is right. But we say that was wrong. Because if one turns to 353, what he did say at 353 paragraph 20 sub 1 is that child support maintenance assessment is the same for welfare benefits and income tax. Fine. Sub 2. It's been established since 1925 that winnings from gambling is excluded from the scope of self-employed earnings for the purposes of income tax. Again, a consistent read. This is not even illegal and it's still included from income tax. It must follow.
Excluded.
Yes, forgive me, excluded. So of course that's consistent.
So he's dealing with gambling here. I mean, I thought that the only reason this was relied on by the Upper Tribunal was that first point.
Well,
as a read across.
Yes, but we are saying a deeper delve into it, my lord, shows that this is our case. Because if under 2, if a gambler is not treated as organising themselves for the purposes of a trade and income tax, of course, the mischief in this case, the court didn't want this individual to say, I'm working as a gambler so I can reduce the amount of my child maintenance allowance. That is what the court was doing. But what I suggest to you, my lords, is that if he is not organising himself sufficient to be self-employed, even in a legal context, with all the sophistication of the facts of that case, it must follow that the appellant here was not organising himself sufficiently to meet the section 2 test. Because one can see there at 20 sub 2, gainfully employed self-employed earner for the purposes of liability to income tax, nor does the regularity, sophistication, or success of his gambling or his employment as a system, at least on his own belief or aspiration, will result in winnings exceeding his losses. So the point my lords make is, well, he was capable of selling bikes illegally and all the organisation that entailed. The Court of Appeal here said, even in a legal context, arguably more sophisticated, more organised, still doesn't come within section 2 of the 92 Act. And we say that helps us. Because, again, the policy concern here does apply. There the court didn't want the individual to offset profits and losses from gambling to reduce child maintenance. The corollary of this applying to appellant here is, I can apply my profits and loss analysis for the purpose of obtaining other benefits. And this was a concern of the court. If one treats the legally acquired earnings as income, and that would apply differently as did in French, individuals might be able to say, well, actually, I'm at a loss of selling bikes illegally. I earned less, therefore I'm entitled to more of this benefit or some other benefit. So the same policy concern applies. And so really, we suggest French helps us, not the Secretary of State. And you have over the page at 354, and I should say that is made expressly clear at 20 sub 2. If such winnings were taxable as self-employed earnings, then gambling losses could be set off against other taxable profits or gains, possibly to the point at which the taxpayer may be entitled to claim welfare benefits. Hacky is referenced. Same applies here. Should be avoided. The way to avoid it is he was not working and he did not have income. The case is relied upon by my learned friends in terms of tax. Minister of Finances Smith at 184, more for your pen than going there, but our broad point is this. This addressed the 1917 Act, post-war as it were, insofar as striving to tax the profits of bootleggers in order to take some of their income, albeit illegally acquired. Very limited application, we suggest, to the facts of this case. And in any event, that was specifically addressing, you have at page 185 to 186 for your pen, It was Section 3 of the Income War Tax Act 1917, very broad, distinct. They were striving to tax in the context of post-war recovery, different policy context. I do want to take you to Aiken, B2.2, starting at page 240. Now, Lady Justice Falk in her permission decision referenced this. You would have seen, my lords, in terms of this being the case that might test the tolerance here for illegal and legal and illegal per se, as it were. And what was happening here is the court was addressing tax in the context of prostitution, itself not illegal per se, but of course the surroundings to that amount to a criminal act of time, and what still do. And it is whether or not there is a distinction between the two for the purposes of tax. If one turns to the discussion, though, at 248, we in fact suggest this helps us, not them. 248, hole punch, paragraphs B through D. Crown does not accept that the illegality of the activities that constitute a trade will prevent it from being a trade within Schedule D. However, I do not need to deal with that. Prostitution is not illegal under English law, and that is not in dispute before us. And goes on. So the court did not find that the act itself was illegal and therefore should be subject to tax regulation. They distinctly set it apart from the other illegal acts. And of course that is relevant because it can't be relied upon to say, well, our read of the statutory regime here is right by Secretary of State. All the court did here was make clear that in my submission it wasn't minded to treat the illegal acts as amounting to trade for the purposes of tax regulation. And if there were any doubt about that...
I don't think that's what it decided. I think the argument that was being run was because being a prostitute in the normal way involved various steps like advertising, renting and so on. And to rent a property for the purposes of prostitution would be illegal. Therefore, the prostitution itself was illegal. Well, I think all that Lord Justice Fox was saying there is, look, on the facts of the case before us, the prostitution is not illegal. It was accepted that the receipts were the fruits of prostitution, and therefore it wasn't necessary to decide the question, if any, the question of the impact, if any, of the illegality.
Some of the discussion we say helps us, my lord, because if one turns to 249,
and he says, sticking with 248, he says, after citing the Irish case, he says, and then decisions of Mr. Justice Rowlett and Mr. Justice Finlay, he says it's not necessary for me to reach any conclusion as to whether profits from an illegal trade are accessible to income tax under the present law of England.
Yes, but this is relied upon by Secretary of State to say, well, this is consistent with our read. We say it doesn't, precisely for that point, however. The reason the court were happy to see it as taxable income was because it pertained to an lawful or not illegal act.
Yeah, but how does it help you? I mean, I can see you can say it doesn't help them.
The discussion I would wish to take you to, my lord. So as I said, if one turns to 249, Lord Justice Parker agreeing insofar as the characterisation of trade. But it's important to say, although the bargains made between the prostitute and her clients are unenforceable as being contrabonus moris, neither the bargains made nor the services supplied are illegal in the sense they are being prohibited either at common law or by statute and made subject to either civil or criminal sanctions. Both bargains and services are immoral, but not all. The point I make there is, it is implicit in that there would be a different decision if the court were applying the tax regime to illegal acts. The court was, in its discussion in my submission, making clear that distinction. And if I'm wrong, even if you're not with me there, you will see at the bottom of 249. referencing an Irish case, Hayes, bottom whole point, the very bottom quote, taken from that, says as follows: I have, after much consideration, come to the definite opinion that income derived from criminal enterprises, that is to say, from enterprises prohibited by law and punishable as offences against the state, is not within the contemplation of income tax legislation. Whilst not expressly brought within that legislation, cannot be supposed to be contemplated by it. I think it demonstrates this to be true, and you will see crucially in my submission, the legislature cannot be supposed to contemplate the carrying on of that which it has prohibited and made criminal. In my opinion, the business of profits and gains to which income tax legislation is directed are lawful business profits and gains. This was ultimately endorsed in Aiken.
No, it wasn't. He says at the bottom of the page, in my judgment, the taxpayer gains nothing from that case.
But my lord, what is not said at the bottom of 250, he does not suggest in reply to that, he doesn't gainsay the analysis, he simply says on these facts we're not applying it.
But he's not applying it, he doesn't think it's any assistance.
My lord, at the bottom of 250, it's made abundantly clear in all three judgments they were dealing only with the case where the activity where the profits were derived was prohibited by Parliament and made a criminal act. It's true that in the judgments there's the use of the word unlawful. It's perfectly plain that where so used, it's not referring to an activity other than activity prohibited by Parliament. My lord, consistent with what is relied upon in that case is, well, yes, this is not illegal, therefore we can tax it. But what he doesn't say there is what was said in Hayes and Duggan was wrong.
Well, he says over the page, sorry, I don't want to debate things with you, but he says it's unnecessary to consider whether the courts of this country should follow the actual decision in Hayes and Duggan on this occasion. I don't propose to say anything on the subject.
Yeah, I don't suggest that that's not what it says, but I simply suggest by implication what the court did not say is obiter, albeit, that is wrong. They just left it. And all I suggest is the case of Hayes is consistent with our approach. Because the court in Aiken may well have said, on reflection, even though on these facts we don't need to go there, we make an observation X, Y, Z Hayes is wrong. It is as a minimum.
So it's the point, the philosophical point, as to whether the view in Ireland 100 years ago that Parliament doesn't necessarily have in mind people not complying with the law, whether that is still a realistic approach in 2025.
Yes, and importantly, because it is expressed in that it cannot be presumed in the top of 250, the case of Hayes.
Yes, okay. But,
You have a point.
Yeah.
None of it is addressing the real issues we have to decide. None of these cases do.
It is a novel area. I go here because this is a case relied upon by Secretary of State.
Okay.
That's the only point. My lords, the position in relation to Partridge and Mann, I'm conscious of time and just for your pen, it's simply to say that we are not sure that the case of Mann, for example, this is a tax case, an old tax case, you have it at 410. There's a tension between the conclusions there. Machines operating commercially deemed to be a trade and profits taxable. Difficult to see how that tallies with French and Mackey in terms of the treatment of trade. But otherwise, my lords, I'm conscious of time. I'll turn my back if I may.
Please.
I don't know if you have anything further, but that concludes.
No, thank you very much. Thank you very much. Yes, Mr. Happenstall.
Well, I can.
Yes, why not?
Yes. Well, let me make a submission on the case law, because I think there is only one submission to be made. I don't know if you could turn to pages 48 and 49 of the core bundle, the Upper Tribunal reasons for decision.
Yes.
Because while I see what my learned friend has done, before doing that, maybe we see what actually happened to the case law in Judge Whiteley's decision. Because at paragraph 32,
yes,
he's dealing with Aiken, but he's not dealing with the Court of Appeal's judgment. He's dealing with the Deputy Judge, Mr. Ashworth's judgment below, and he's making clear at the top of page 49 that it was obiter for the reasons given by my Lord Justice Miles. he's just relying on that obiter passage that he then cites, that various courts have repeatedly rejected the argument that a trade ceases to be a trade for the purposes of the Taxes Act because it's illegal. And that's really the only bit of case law that the judge below relied on, because, as again was pointed out moments ago in argument, Hacking French, he's only doing the read across point between tax and benefits. That's all it is. Now, I understand that my learned friend has looked at those cases and sought to run with them, but that's all that's happening with the case law. And then finally, Best at paragraph 35, well, the learned judge doesn't go anywhere with Best because he says it's a completely different situation with different competing public interests at play. You see that paragraph 35. Now, my learned friend may take the point, well, you've been relying on case law, I want to rely on case law, but I think ultimately the bottom line is that this point is novel, has not been before this court before, had not been before the Upper Tribunal before, and the work I've got to do after the short adjournment is to get back into those regulations and take another look at those provisions. And I don't intend to go back to the case law. Whatever the decisions have been of this court on prostitution, gambling, is it a trade, is it not a trade, is it taxable, is it not taxable, the fact that adverse possession was a tort before it was a crime, and Limitation Act bit on a tort, why is it not bite on a crime? I don't think in my submission those are going to assist this court with the question of statutory interpretation that's before it. So
yep.
I can either...
No, we might as well stop there.
Stop there.
And we'll start again at 2 o'clock. How long do you think you might be? Subject to...
subject, with the important caveat, subject to interventions. I'm hoping to be no longer than an hour.
Thank you. Thank you very much.
Are you on full now?
Leave all the stuff in here.
It's going to be locked.
Yeah.
Go around to that table around the corner we were before.
Yeah. You can do, yeah. But, it will be locked.
Yeah. What can you do? think they just sort of